Hello, this is Brian Rowe for NIIP, episode 4, which covers Catcher in the Rye and injunctions. Before really getting into this, I wanted to acknowledge how important this novel has been to a lot of individuals' upbringings. I did not realize that until recently in working on this particular episode. Catcher in the Rye is assigned in several schools here in the US and has affected how individuals look at the world. It's not that great of a novel to me. I'm much more of a Nietzsche and Camus fan, but Salinger also recently died during this lawsuit, which is currently still ongoing. Let's look for a second at the background of the lawsuit. Catcher in the Rye is still in copyright at this point, which means that in a lot of cases you need the permission of the author in order to take large amounts of it and reproduce it, to remix it in many ways. And that's really what's at issue here is, can someone else build upon this creative work in a new, transformative, different way, even if the author does not give you permission? What happened is an author, Frederick Colting, or that's actually the pen name for John David California, wrote a book called 60 Years Later Coming Through the Rye, which is currently commercially available. This book is based on what if the main character, Holden, was still alive today? What would he be like? What would be going on in his life? It is in no way portraying itself as an official J.D. Salinger authorized sequel. It is an unauthorized, transformative work that really builds on something that has become a cornerstone of our culture. Salinger did not like this at all. He wanted control of the book and did not want anyone writing a sequel. So he went to the district court and asked for an injunction. Now let's step back for a second and look at what an injunction is. An injunction is where the court orders someone either to do something or to not do something. This is very different than the remedy courts really like to give, which is monetary damages. The courts really usually shy away from injunctions because it infringes upon an individual's liberty. It's telling me what to do in a civil lawsuit. Now, in copyright, traditionally, injunctions have been granted much more often than they are granted generally. This brings us to a really important patent case. And you're thinking, why am I taking you down the rabbit hole of patents? Patents and copyrights, and in some cases trademarks, are really the same type of creatures. The laws that apply to one often apply to the others. One example of this comes from the Costco v. Omega case. We looked at the for sale doctrine, which is codified in section 109 of the Copyright Act. The exact same idea is in patent law. It's a doctrine called exhaustion. It's not in the statute, but it's in the case law. And the Supreme Court recently looked at and strengthened that doctrine in Quanta v. LG Electronics. This is one of many examples where parallel doctrines in one area really apply throughout to all other areas of law, or at least all the way through intellectual property law. Now, why is this so important that we took this aside to look at patent law? There was a recent patent case called eBay versus Merck Exchange. In this case, eBay was sued over their buy it now function. This is a function where you can click and buy something for a buyout price on their auctions. And Merck Exchange has what I would call an extremely questionable software patent that covers a lot of e-commerce, including buy it now. And Merck Exchange wanted to shut down eBay's buy it now function and basically hold them ransom in order to use that feature. The Supreme Court looked at this case, looked at the fact that Merck Exchange did not have a competing item in the marketplace, and applied a 4-factor test that included the public interest and how they would be harmed by an injunction, and decided not to grant an injunction in this case. Now, the district court in the Salinger case looked at this and said, no, that's not important at all. That's a patent case. It doesn't apply to copyright here. In copyright, we've got our own things. Fortunately, the Second Circuit on appeal, when looking at preliminary injunction, said, no, this eBay case, it really matters. There's 4 factors. We have to look at, is there irreparable harm? Can they be compensated through some other scheme like licensing? What are the interests of the defendant in this case? And what are the public interest concerns? When you look at those 4 factors, it sets a very high bar for injunctions to be granted. And in this case, a preliminary injunction, which is an injunction at the very beginning of the case, was not granted. And it was not granted for several different reasons. One of those being is that monetary damages may be enough. I mean, you've got an unauthorized sequel here. Why not just give them a percentage of the proceeds? Why resort to censorship? There's no reason here to resort to censorship. Additionally, the Second Circuit also looked at fair use. Fair use is really the codification of the First Amendment in the Copyright Act. It's free speech in the Copyright Act. The author of this unauthorized sequel has a very strong fair use defense. He's really doing something transformative that the author would never, ever authorize in this case. So, with those factors, an injunction doesn't make sense. The answer to speech you don't like is always more speech, not censorship. Lots of authors have understood this. The author of Don Quixote, when dealing with an unauthorized sequel, wrote a satire of that and then wrote his own comments on it. So this case is really a case where we're looking at a restriction of copyright law to prevent censorship. And it's going to be very interesting to see how the fair use defense comes out at the end of the day. Thank you for listening to New NIIP, Episode 4. This is under a Creative Commons by license, which means you can redistribute, remix, and reuse this as long as you give credit to me, the author, Brian Rowe.